Good morning and welcome. It is still morning, yes. Good morning and welcome to the Court of Appeals today. I am Judge Michelle Christensen Forster. I am the presiding judge of the Utah Court of Appeals. I am joined on this panel today by my colleagues Judge David Mortensen and Judge Ryan Tenney. And I need to take just a moment of personal privilege to say how excited we are to be here. It has been, well, it's been 3 years since we have been down to SUU to hold arguments. It has been 2.5 years since we have actually had in-person oral arguments. So if I seem a little discombobulated, it's because this hasn't happened in a very long time, and I'm very excited, and I know my colleagues are as well. I also want to take a second to thank Ryan Paul, who is the Apex Director, and also to thank Trooper Barrett, who is providing our security today. We appreciate that very much. Just a little introduction. The Utah Court of Appeals consists of 7 judges. We sit in panels of 3. We hear arguments on challenges to what happened in the trial court. The Court of Appeals, an appellate court, does not take evidence. We don't have witness testimony. We hear the arguments from counsel, and will be arguing about what they feel either went wrong or what was wrong by the trial judge's decision. So no live testimony today. You just get to see us and hear us ask questions. So with that introduction, counsel, could you please introduce yourselves and make your appearances for the record?
Good morning, Your Honors. Alexander Dushku for the appellant, Rainfocus. I'm here with my colleagues Michael Eisenberg and James Brown.
Good morning, Your Honor. Mark Brassett with Greenberg Trotter here on behalf of the appellee Cvent, and with me is my colleague Juan Pedersen.
Appreciate that very much. Each side has 15 minutes in which they may make their arguments. The party bringing the appeal gets to reserve time to have the last word. And so it appears, Mr. Dushku, that you have reserved 5 minutes for rebuttal.
That is correct.
Perfect. Yes. And not to distract you, counsel, but after these oral arguments, we are going to excuse you, allow you to leave right away, and we will take questions from the audience. We'll come down from the bench and we'll take whatever questions you have. We can't talk about the case and how we may rule on the case, but we can answer questions about the court, about our procedures, anything else just not related to the case that you're about to hear. So with that, Mr. Dushku, you may begin.
Well, good morning, Your Honors, and may it please the court again. Alexander Dushku for the appellant, Rainfocus. I'm grateful to be here this morning in this unique setting. Never thought I'd be arguing in Hogwarts, but it's great. It's great to be here. As you know, this is an appeal from the erroneous granting of a motion to dismiss against Rainfocus. Cvent filed a complaint in federal district court making what we have alleged are false and defamatory allegations claiming that Rainfocus misappropriated its intellectual property. Cvent executives then took that complaint on the road and went to individuals who are not in any way connected to the litigation. They went to prospective customers of Rainfocus and proceeded to recite and review their allegations against Rainfocus. It told its customers that Rainfocus had misappropriated its intellectual property, stolen its intellectual property, plagiarized its source code, and so forth. Now, of course, the filing of the complaint in federal district court is privileged. They can say anything they want there. However, that privilege does not extend to using that language, using those allegations outside of that judicial proceeding context.
Can I ask you a question about
yes,
that? Are they allowed to tell people that they're suing you?
Yes.
And that would not be subject to defamation?
Correct, as you have described that.
Are they allowed to tell people, quote, we're alleging in our lawsuit the following? Or does that cross the line?
That can very well cross the line. They must be extraordinarily careful because, Your Honor, allegations in a complaint, again, which you can say anything you want in a complaint, those allegations can be very destructive of a person's reputation or a business's reputation. For example, you could be arguing, you could allege that so-and-so is abusing a child, and then to go outside of the judicial proceeding and start talking about that allegation, even truthfully reading that allegation, can be extremely damaging to a person's reputation, and hence is beyond the scope of this privilege.
So if I've got it right, they're allowed to say we're suing them, but the moment they get into the details of their allegations, that's where they in theory cross the line into defamation territory.
That is correct.
So if that's right, then doesn't defamation law become something of sort of a gag order on discussing a lawsuit globally? Because it seems to me that in most lawsuits, if not all lawsuits, the two sides are going to have differing views of the facts. I mean, that this is why they're in a lawsuit. One side thinks the facts are X, the other side thinks the facts are Z. And if we wrote an opinion saying the moment the other side says, you know, this is our view of what's happening in the lawsuit, that they're subject to defamation, then I think the net effect of that is that you just simply can't talk about a lawsuit at all, or the substance of a lawsuit, without being subject to defamation.
Your Honor, you must do so with extreme care. And that is the clear teaching of the Utah Supreme Court in the
What
Pratt.
does that mean? What can they say beyond the bare fact of we're suing for a cause of action A, B, or C? What else can they say?
Well, that's going to really depend on the context. There are situations where general counsel have been extremely careful in saying, you know, in describing in very general terms, very careful terms, a lawsuit. But you cross that line when you begin essentially reaffirming and using those allegations to disparage the reputation of your opponent. The Pratt, Your Honor.
What if any discussion that you may have involving the lawsuit and the allegations in the lawsuit are qualified with, we believe, we have concluded, we think, we, you know, what about those qualifiers? Does that change the analysis at all?
You know, it does get into the context and the setting of what is being expressed. So there is this fact versus opinion line. And as you know, the Utah Supreme Court in the West against Thompson Newspapers case, which is really vital. There are two cases, just as an aside, there are two cases that really control this, the Pratt case and the West case. That's the controlling law here. And in the West decision, the court talks about a number of factors that would take it from opinion to fact or from fact to opinion. And so you're going to look at what it is that's being said, the common usage of what it is that's being said. You're going to look at whether it's capable of being verified as true or false. If it is, it's on the fact side, the defamation side of things. And then you're going to look at the context and setting of where it was said, who said what, and what was going on. There are lots of complex questions here, Judge Tenney, that get right up to the line. And the courts are going to have to work that out. But what is not complex is a setting where a competitor files a complaint and takes that complaint and goes to a potential customer and says, this is what we've alleged, this is what we believe to be true, that we have evidence of this, we have experts who have said this and believe this is the most egregious, that was the actual word, the most egregious case of intellectual property theft that they had ever seen. In that context and setting, we are talking about defamation, and that's this very context and setting.
Can I ask you a question
Please.
about the sort of the standard of review, in the sense of you assert that Judge Lennon needed to take all of the allegations in your complaint, in your defamation complaint, as true, and that, which means that we start from the assumption, from the point of view that Cvent did do all of these things. Is that where we start?
Yes, you begin with the allegations in the complaint. Most importantly, that we have alleged that they have falsely accused us of doing certain things. The falsity allegation is one you must absolutely assume to be true. Okay?
But that is the subject of a dispute, a federal dispute.
It is.
A federal lawsuit that's been going on for quite some time.
It is, Your Honor.
Don't we have to sort of wait for the resolution of that lawsuit to know what the truth is in this situation?
It is the case that the truth of these allegations, which is really the underlying matter here, the truth of whether Rainfocus indeed misappropriated intellectual property, is going to have to be determined in that federal court setting or in some other setting where those issues are finally resolved. So that is certainly true. But what we have here is an allegation that what they allege there is false and defamatory.
And that's where we start. That's where the trial court should have started.
That's where the trial court should have started. And of course, it is a question of law as to whether words are capable of a defamatory meaning. So we're not suggesting that we just get to simply say that any old word is capable of a defamatory meaning. But words like misappropriate, plagiarize, theft, and so forth, those are words of defamation. Now, what they argue is that they have a fact-based defense and an opinion-based defense against our position. Neither argument has full merit. You cannot truthfully and accurately describe the allegations in a complaint and just get out of jail card. That's not how this works. The Pratt case is very, very clear on that. Paragraph 35 of the Pratt case, and then you go over to paragraph 47 of the Pratt case, and the court says that if that were the law, then it would simply be, all you'd have to do is stuff something into a complaint and just walk around and you could defame people. That would be a license to defame. And Utah law has never countenanced that. Now, on the opinion, again, versus fact line, as I've already mentioned, the context and setting here are vitally important. We have alleged.
So hedging matters, right? So with your two examples you gave us, one with the child abuse, if you said, in our opinion, and even if they hedge this much, in our opinion, recognizing that the evidence is subject to interpretation, we believe that child abuse occurred here. Does that put it enough in the box of opinion that we as a matter of law would look at that and say, look, they hedged enough. The hearer of that statement would understand that it would be opinion.
I don't think so, Your Honor. And I would take a look at the decision in the West case, page 1015. This is a very important...
Can I ask you my follow-up question? Because I think your
please.
answer is going to go to both. The other one was as to this expert. If they said something with the introductory language of, we understand that the evidence, again, is subject to interpretation, we are relying on the opinion of a third party that this is the most egregious case, not endorsing it, just like, hey, we've got this expert here who's telling us these things, just so you know that's his opinion, and saying it's his opinion. Does that tell that, again, both of those? I didn't want to ask the same question twice, and I think your answer is going to be the same as to both. So,
Your Honor, I see that my time has expired.
No.
May I answer the question?
Please.
Okay. I think that's not enough to get you there. And let me tell you why. That is not enough to take it from opinion over into, that is from fact over into opinion. If you'll take a look at the West case on page 1015, there's this very insightful paragraph where the Utah Supreme Court says what we all know to be true, quote, opinions rarely stand alone, isolated from any factual moorings. To convince readers of the legitimacy of an opinion, authors typically describe the perceived factual bases for opinions, seeking to demonstrate that the author's opinions are grounded in common sense. And then it says this, thus, Article 1, Sections 1 and 15, these are the constitutional protections under Utah law for free speech, protect expressions of opinion, and this protection is abused when the opinion states or implies facts that are false and defamatory. In other words, you can use that expert in order to send and imply a false and defamatory meaning. This is a totality of the circumstances.
But why doesn't the fact of the lawsuit change the analysis at least somewhat? I mean, we've got all these doctrines that talk, the open courts doctrine and various constitutional provisions that seem to sort of collectively say that the public has an interest in following court proceedings and tracking court proceedings. And if we then say to litigants who were involved in court proceedings, you just can't talk about the stuff that's going on in this case, even if it goes on for years and years and years without being subject to a defamation suit, haven't we undermined that protected public interest in being able to publicly discuss what's going on in court?
I don't think so, Your Honor, because there are other forces involved. For example, the press. The press can clearly access court dockets and can describe what is there. There's basically fair press privilege. So that's one of their important functions within our constitutional system. And there are ways to describe a lawsuit that are much more objective and that can move it into the zone of opinion. But you got to be careful. And here they were not careful. And you can't be doing that in a context where you are clearly intending to defame another party and take away their business.
The defendant? I think one of the things that sort of tilts the equities in this case is that they're the plaintiff in the federal suit. But let's suppose they'd been the defendant instead. Let's suppose, in fact, let's take it out of the realm of them. Let's just suppose that entity A is sued, and they feel like they've been sued unfairly. And the people that do business with them come to them and say, we understand you've been sued. What's going on? If I'm taking your position I don't even think it's extremes. They'd kind of have to say, well, we can't really talk about that because if we do, we're going to be subject to a defamation suit. And if the case goes on for years and years and years, that in and of itself may impair their ability to conduct business. So why isn't that a problem?
Well, you certainly can say we have denied those allegations. You certainly can say here is the body of evidence that has been accumulated, and we provide it to you to review for yourself. You can certainly do that. And I think there are a variety of other things that can be done in order to say we have not done the things they have alleged against us. But remember the Cosby cases, where he was alleged to have done these terrible things, and then he lashed back out and called everyone a liar and other defamatory things, and the court said you can go forward. So litigants in a lawsuit do have to be careful, because the privilege only goes so far.
So just to be clear, if A sues B, if company A sues company B, and company B is asked about that lawsuit, about the stuff of the lawsuit, and company B says to its friends and its business associates and so forth, hey, we just did not do those things they're accusing us of doing. We did not do them. Why wouldn't that be defamation under your rule, your proposed rule?
Because they haven't defamed the other party, I don't think. I mean, they've simply denied a defamatory allegation against them. There may also be, which has not been alleged here or not been argued here, there may be a privilege of talking to an interested party in that context, someone within your business, within your immediate setting. But again, that hasn't been argued here.
Can I ask you, I'm sorry.
Certainly no.
I know you're over your time, but we'll give you your full 5 minutes on rebuttal. The one allegation, I think, or instance of defamation that does bother me, and it probably bothers you a little bit, and I'm not sure that the trial court necessarily engaged in fully discussing why it wasn't defamation, is the statement in the email that suggests that Cvent has evidence. We have evidence. We have evidence. We have evidence of this. What is the distinction that you're drawing? What if they do have evidence? Why, and there is a federal case going on, discovery's been propounded, and the case is occurring. Why is that defamation? Why is that allegation false, I guess, is a better way to ask it.
Well, if they indeed have, if what they've alleged is true, then they have a defense to the defamation. Mm-hmm. So of course that's the situation they're in. But merely asserting that you have evidence is quite a different story. This is what they said: copyright infringement. These are the notes, at least. Of course, we haven't had a chance to engage in any discovery. This is just one little page of notes from what is clearly a lengthy meeting, and we don't know all the things that were said, good, bad, and ugly, in that context, and that's one of the problems on a motion to dismiss. But here's what they say, quote, "We have evidence that they have actually duplicated or plagiarized significant portions of our source code," end quote. that's a defamatory assertion. Now, if that is indeed true, that the evidence shows that, then of course they have nothing to worry about.
Sorry.
No.
I know you're trying to sit down, but you've now told us a few things you can't do. I want to ask what you can do. So, they could, I think you would concede, write to prospective clients, or certainly clients they have that they think you might be competing for, and say, we have filed a lawsuit against these folks. The fact, they can communicate that they have filed a lawsuit, right?
I believe so, yes.
Okay, all right. So next, let's say they get an email back, because this whole thing we're looking at here for the most part is a bunch of email chains. They get this email back, and the person says, well, what evidence do you have of that? They ask. And my question is, what could they say about that expert opinion? They've got this expert who says, this is the most egregious case of misappropriation I've seen in my life. What can they tell someone who asks, what evidence do you have of this? As to this expert, what could they say? Or is your position they just can't talk about that expert?
Certainly that's the safest thing for them to do, because they're entering into a zone of, of defamation.
But here we are, so we're not going to talk about safe or smart.
You're right.
We're going to talk about the line. Where is the line?
Look, I think people are entitled to say, here is evidence, and you draw your own conclusions. I think that's right.
But
and as far as
can
how
I
much
push
you
back
can
a little bit on that, because
Please.
I don't think that's what your brief tells me, because the sentence that just came out of your mouth seems to infer that I could, in response to their question, I could package the expert's report and just send it to them. Could I do that? Because it seems to me like your position is that the expert's sentence coming out of the expert's mouth itself is defamatory.
Our position is their characterization of what their experts said was defamatory.
Okay.
And that's an important distinction, especially in the context. They're basically making the case in front of a potential customer trying to take away business. So that's the problematic context
So they could
there.
send the expert's report?
I don't know, to be really honest. I don't know where all of these lines are. I just know that this one is way across the line, given the context and setting.
But let's suppose that they did the version that 2 answers ago. Let's just suppose they said, here's the expert report. Is the expert then subject to a defamation suit?
No,
Why not?
because his report was given in the context of a judicial proceeding, and it's privileged for that reason.
But it'd be more problematic if the expert got out there and started
Yes,
spewing.
that would be
Yeah.
problematic.
Okay, all right.
Discussing it, and so forth. So again, exactly where this line is, we're going to have to feel our way forward. We don't have a disaster in the middle of defamation law going on right now where no one's able to talk, okay? We do know that this situation actually is quite unique, where you take your allegations on the road, you take it to potential customers for the very express purpose of denigrating and defaming your competitor to take away his business. That is a very, very different situation, and that's the exact situation we have here. Thank you, Your Honors.
Thank you, Mr. Dushku. Mr. Rasich?
Good morning, Your Honors. May it please the court, again, Mark Rasich, on behalf of the appellees Cvent, Inc. This court should affirm the order granting the motion to dismiss Cvent, Rainfocus's complaint below. The statements at issue were made in a series of communications that are non-actionable because they are either true statements of fact about the litigation below, or they are constitutionally protected opinion. 3 courts have now looked at these statements, or statements substantially similar, and each have concluded the same thing, which Judge Lunan says on page 13 of her order. The challenge statements are true statements about pending litigation or ancillary reports, mere opinions about whether Rainfocus misappropriated Cvent's intellectual property, and statements reflecting optimism about the outcome of the case.
Can I start you off with a question about that?
Yes.
In response to what you just said, in the reply brief on page 3, Rainforest says, and I'll just quote them, because I think frames my question well, quote, "It is important for this court to understand that Cvent's position would mean that filing a complaint creates a license to defame." Are they right about that as the import of your position?
No, Your Honor, they're incorrect about that.
Why?
There are already existing principles and rules of law that can deal with the context in which someone files a completely malicious and fraudulent complaint, abuse of process, malicious prosecution, frivolous lawsuits where you obtain your attorney's fees at the conclusion of those things. When you're talking about something outside of the context of the judicial proceeding privilege, there's already a test in place set forth by Thompson newspapers, which gives guidance for courts like yourselves to determine when statements made outside of that proceeding may or may not be actionable.
Okay, let me ask you a hypothetical. I've tried this a few times, and sometimes it works and sometimes it doesn't. Hopefully we're in the former. Suppose that person A publicly accuses person B of sleeping with her husband. Ordinarily, B could sue for defamation, right?
I believe so, yes.
Okay, so let's suppose that instead of just running around and telling everybody, hey, B slept with my husband, person A instead sues B for loss of consortium, and the whole lawsuit is predicated on the allegation that B slept with her husband. Can she run around and tell everybody, hey, look, I filed this lawsuit, and here's the allegation in the lawsuit, and what happens in the defamation context if that happens?
So, Your Honor, I think one of the cases has said this, but context is king, and so given the context you've just described, assuming that the underlying fact is false and assuming the person is literally running around telling whoever she can find those sorts of statements, I think applying the four-factor test in Thompson versus newspaper, you could conclude that given the context, the statements are false. There may or may not be verifiable
right,
false.
But if I understand the position you've taken in the briefing, what she would then say in response is she'd say, look, all I'm doing is discussing the allegations in a pending lawsuit. We have a pending lawsuit about a loss of consortium. I've made these allegations in this lawsuit. I'm entitled to discuss the lawsuit. How's that any different than what's happening here in this case from your end?
First, the context of the statements are different. One, we were asked to provide information about the lawsuit from customers or potential customers. That's different. Two, the statements we made are replete with cautionary language and expressions of opinion which would signal to a reader, just like the court in Thompson newspaper said, that what they are about to read is not fact, but rather opinion. So those are reasons why the context you just provided compared to where we are today is completely different and should result in a different conclusion under the totality of circumstances test.
Can I ask you, oh,
Sorry.
I know I can ask. Can I interrupt him? The specific statement, and I think it's on record 388, the email exchange, the discussion about the lawsuit itself, and there are statements in that email. We have evidence. We have evidence of this. We have evidence of that. There's no qualifier there, not at all. There's nothing we believe the evidence will show. They are statements of fact. Why aren't those statements in and of themselves enough to, for the court should have denied the motion to dismiss?
Your Honor, I think...
Doesn't that get you over the hump, if you will?
No, it doesn't, Your Honor, and it doesn't because of context. Courts from the beginning of time have had this question: at which level, how low, how parsed can I go, and in making a determination of whether something is or is not defamatory? The teachings of Thompson newspapers and the courts that follow the same multi-factor totality of the circumstances test suggest and teach that you do not parse down to individual lines or individual phrases. You take the entirety of the communication, including the broader setting, and then you make your determination. We've cited the court to a number of cases where there are statements that in a separate setting, in a different context, might be considered to be factual and might be considered to be defamatory, but in the context in which they are made, they are not defamatory, and they are not actionable. This is one of those
But to the extent that
cases.
this turns on context, why isn't the relevant context here that it's a business speaking to a potential competitor or a potential customer of its competitor? Why isn't that the proper context?
Well, that is a factor, but in this context, we were asked to provide the information. Cvent was asked to provide information about it.
Why does that insulate it, though, as far as defamation goes? I mean, if somebody asks me a question and then I respond with a false statement, it's still defamation. And the fact that I'm responding to a question doesn't change that, does it?
It's not the only factor, Your Honor. I would agree with you. If the only thing that
But why does it
happened-
matter at all? I mean, bear with me on that one. Why
Sure.
does it matter at all? If they're asked by one of Rainforest's potential customers a question, why does the fact that there was a question that preceded the alleged defamation change anything about the defamation part of it?
Because it goes to the intent, not the intent, but the circumstances around the communication. So if I decide I'm going to go and publish something, or in your example, run around and tell the world, that is a different broad setting compared to I was asked and I responded to the persons who asked.
But why does defamation care? I'm acting as if defamation is an entity, but why does defamation care? I thought the whole point of defamation was there's truthfulness behind this statement, or there's not truthfulness, and it's going to harm the person or it's not going to harm the person. Why does it matter if it comes in response to a question or if it's instead volunteered?
I think it's just one of the elements to be considered, Your Honor. It's not, I don't believe that it's determinative. I think if you could set a hypothetical instance in which someone was asked for something and they provided a completely defamatory response in response to that question, and even under the totality of circumstances, that might be considered defamatory.
Okay, so moving back then a layer to what we were talking about a minute ago, why, this is the piece of that part of this question that I'm struggling with. Why is the context here not two businesses fighting for customers? I mean, it's sort of hard to escape that as something of a gorilla in the room. And maybe it doesn't matter, but maybe it does. But from their perspective, what they're saying is, no, the context that matters is Cvent is going to Rainforest customers and saying, don't give Rainforest business because they've stolen our property. And so to the extent that context is driving the defamation analysis, why isn't that it? Why isn't that the context?
That is part of the context. The communications are between sophisticated business people. The context of the communications is, on the one hand, executives from Cvent, and on the other hand, executives of these individual entities. Those entities, of course, know that there is a lawsuit. They, of course, know that the plaintiff is Cvent, so they are going to, of course, understand that what Cvent provides in that communication is going to be couched in the terms most beneficial, most slanted, I should say, in favor of their position, because they are, of course, the plaintiff, and anyone receiving a description of a complaint from a party in a lawsuit is going to assume they are providing that description in the light most favorable to them, which is exactly what the courts say.
But when they also
considered.
assume that they'd be speaking truthfully, though, which is one of the things that would make it potentially defamatory.
Well, I think every lawsuit about defamation
Fair.
has to start with, I'm assuming that everything you're saying is false. So I agree that if someone was out defaming somebody and all the other contextual factors were not there, that would be one thing. But if you are talking about a lawsuit, you're either describing the lawsuit accurately, meaning this is where the lawsuit is, like in our case, here's where we filed the lawsuit. Here's the case number. Here's the case name. The executives can go and look for themselves at the docket. Counsel was suggesting a newspaper could do it. So could these sophisticated business people. They could see that we filed a complaint. They could see that Rainfocus filed an opposition. They could see that we filed a preliminary injunction. They could see that Rainfocus opposed the preliminary injunction. They could see what the judge ruled. They could see that we've been fighting for more than 5 years about all of these things tooth and nail, which is exactly what Cvent told those business people that it would do. So in the context of the statements, the broader context, and then also within the specific context of the statements themselves, a reasonable person reading the statements, a person, the audience in this case, two business people, reading those statements would understand that what they were about to read or were reading was opinion and not fact.
So and I think the record that we're looking at has been talking about mostly here is this 136, the one that says we have evidence, and that is in response. The first sentence says you've asked about, or I guess the second sentence, you've asked about this. If take away that context, so this isn't you asked about it. Cvent just decided we want to give these people a heads up about this. If you took out that sentence that says it's in response to a question, and instead it was just we're going to go out there and put the seed of this idea in their head, would that change it fundamentally enough to make it pass muster or withstand the motion to dismiss?
No, it would not.
Okay, so what is it about the state? Because is your answer going to be that there are other indications that this is opinion and not?
That's correct, Your Honor.
Okay, point to me. I think one of the things you point to is the last, or the penultimate sentence on the bottom of 136 says, we strongly believe. So you're couching that as an indicator of opinion, right?
Correct, Your Honor.
Okay, take that out. Now what's left that would be an indicator of opinion?
So are you asking me if we take each cautionary indication of we've sued for,
Well, I'm
we've
just
claimed
taking
that,
two things out is all I'm taking out. You're taking out the prefatory language that this is in response to a question, and you're taking out the we strongly believe. What is left in here that makes it indicative of an opinion versus an allegation?
the broader context, number one, we are a plaintiff in a lawsuit. The business people understand we're a plaintiff in a lawsuit. It's a reasonable audience would assume and understand that we were going to be providing.
How
things
does
in
the
most
district
favorable light.
court get that, the broader context, on a motion to dismiss? As
It knows
opposed
there's
to-
a lawsuit because that's the underlying.
Right.
The underlying claim is that Cvent maliciously filed a lawsuit full of false and defamatory statements that have been being litigated for 5 years. So the district court below
Well-
clearly understands that context.
Okay, but how would they know, for example, the level to which they're sophisticated parties?
They understand that they're business people and they are doing business with Cvent, Your Honor.
Because this is kind of interesting. Normally, when you tell me that the court below looked at the totality of just the circumstances, we defer to trial courts when they look at the totality of circumstances. We don't defer to trial courts when they look at the totality of circumstances on a motion to dismiss, right?
That's correct, Your Honor. It's
And we
de novo
don't
review.
defer in this case to how the district court viewed the case. But unlike most cases in a motion to dismiss, not only do we not defer, but we infer, we make inferences in the other party's favor. Defamation law is a little bit different in that regard, right?
Significantly different,
Yeah,
Your
yeah.
Honor. It's the opposite.
We don't do that.
it.
We
Yes.
don't do that, right. But we don't do it either direction, right?
You don't do it either direction. no,
Okay,
Your Honor.
all right. So it's just objective totality of the circumstances, I guess is what you'd call it.
It's essentially, yes, the totality of the circumstances, and counsel is correct and the court is correct that there is no bright line. I know in most cases, courts would like me to explain to them where a bright line is, but as the Thompson newspapers court said, and many other courts have said, this is a unique circumstance. There is a heavy weight on one side, the First Amendment, and there is a weight on the other side, the right to protect your reputation. That's why there is a totality of the circumstances test. In our case, that totality of circumstances, given the broader context in which the statements were made, the specific statements in the statements themselves, in the emails themselves, and the words themselves lend to that setting, which the Thompson newspaper court recognized, where there are settings where a reader understands that what it's about to read is going to be opinion, not fact. And even if Cvent did not say per your request, that's one factor in a much broader picture and not determinative on its own.
Why isn't the answer to this conundrum the second factor that's listed? I mean, just so we're looking at the same thing, on page 30 of the blue brief, it cites language that both sides have accepted, but it's in the block quote at the bottom of 30, and it gives the 4 factors that the Supreme Court has given us from West. And the second factor kind of jumps out to me, given the discussion that we've had. And the second factor asks whether the statement, quote, is capable of being objectively verified as true or false. And that seems to say that what this sort of opinion versus fact divide is about, is this thing we're talking about factual in nature, or is it sort of subjective? Is it sort of, I like this movie, you like that movie, right? And so if we zeroed in on that factor and looked at whether it's, quote, capable of being objectively verified, you'd lose here, wouldn't you? Because the stuff we're talking about is, did they steal the source code or did they not? That's capable of being verified or not. So why couldn't we just look at that second factor, kind of elevate it a little bit, and work our way through the conundrum that way? What would be wrong with doing that?
Your Honor, there would be a lot wrong with it. First of all, you're not considering all the context. Secondly, as a number of courts we've cited to the court have said, statements in one context may be factual enough to verify as true or false, but in other contexts are not, that they are, given the setting, given the overall setting, the context in which those statements are made, they are not actionable statements of fact, but rather opinion. We've cited, Your Honors, to the Karp case, the Southern District of New York case, where the statement at issue was that someone had defrauded someone else. That's, in a different setting, might be a fact that was capable of verification, but the court in that case found the statement in the totality of circumstances to be non-actionable. Similarly, we cited, Your Honors, to Dreamstone. In that case, the allegation was that someone had maliciously stolen intellectual property. Again, set aside the word malicious, stolen intellectual property is something which, in a different context, after a long trial and a jury and maybe an appeal and back and forth, someone could probably determine whether that actually happened or not. But in the context in which that was made, with cautionary language and the rest of the settings that we've described for Your Honor in our briefing, the court there found that it was not sufficient. So it doesn't end the inquiry. There are 4 elements. All 4 elements should be considered.
So you're saying even if the second one goes against you, the rest of the surrounding contextual cues just pull it into the opinion realm?
That's correct, Your Honor. That's essentially one of the findings of the Dreamstone case. So, well, I think I've been a little bit beyond my time, but I would just to summarize in conclusion, that the district court was correct. The district court correctly considered all of the contextual factors, the broader setting, the statements themselves, and given the case law that we've cited to this court, the reasonable person in the shoes of the recipient of that information would understand that they were receiving something that was an opinion and not a recitation of fact. And because the defamation claim fails, so does the underlying intentional interference claim. Thank you, Your Honors.
Thank you.
Thank you, Mr. Essich.
Your Honors, I think I can be quite brief. I want to get back to something that Judge Tenney mentioned. If that second factor is as clear as you articulated it, you're going to have to really, really have some powerful stuff on the second, on the third and fourth factors, on the context and setting factors. And for them, that additional context is actually terrible, not good. It is the context that we've discussed repeatedly of going to potential customers of your competitor and trying to defame them for the purpose of taking away their business. That's not positive context. That's very negative context. Now, not that it matters, but it was mentioned in the colloquy. Paragraph 44 of the complaint, Cvent reached out proactively rather than in response to any inquiry. That's what we allege. And that is to be taken as true for purposes of this proceeding. Of course, discovery will demonstrate in the whole context and setting analysis that needs to occur whether that is indeed true or false. These statements on page 136 of the record, this is an effort, by the way, by a general counsel to make the case that there has been a misappropriation of intellectual property. I mean, he's making his case. We sued Rainfocus for, among other things, copyright infringement. We have evidence that they have actually duplicated or plagiarized significant portions of our source code. Trade secret misappropriation. We have evidence that they are using our confidential and proprietary information and trade secrets, including product designs, client requirements, details about client contracts and marketing strategies, to lure customers. Later on, steal clients. Our experts are going to back all this up. He's making his case. He's making his case to convince Autodesk of a particular set of factual allegations. Now, if they're correct, they're perfectly fine. They have nothing to worry about. But we have alleged, and it must be assumed to be true at this stage, that those allegations are false, that we did not, in fact, do that, and therefore a proper claim for defamation has been stated, subject, of course, to all of our burdens of proof, which are going to be very substantial, subject, of course, to what's going on in the federal district court and the adjudication there. There's lots of issues to work out there that are not present before the court now. But in any event, this matter should not have been dismissed. The totality of the circumstances analysis is a very factually intensive analysis, and in this particular case, who said what and what people understood as being said and so forth is going to be part of the case. And moreover, as we have alleged, we believe this was not the only time this happened. Upon information and belief, we believe this was just the tip of the defamatory iceberg. We're entitled to additional discovery on that as well. Thank you, Your Honors.
Thank you, Mr. Dushku. A very interesting case, and we appreciate so much you attending these proceedings and, coming here and joining us for this great event. We will take this matter under advisement and render a written decision as soon as we possibly can. And with that, we are in recess.
Tell them we're now going to come down and.
I don't think we should. Oh, that is fine.
You want to tell them?
Thank you, Your Honors.
So, whoop, can you hear me now? Can you hear me now? Can you hear me now? You can't hear me now. That's okay. All right, so we are so excited. You can hear me? Now you can hear me? Oh, there we go. There we go. Thank you. So we're so excited for the opportunity to have the judges here, and what I'd like to do is invite you. We have a few minutes for some questions and answers, but you may want to come a little closer. I mean, not this close, but a little closer so we can have that. There's a microphone over there so they can hear and respond. But first, if I could start, my name is Ryan Paul, by the way, Direct Apex. Could we just have kind of a how we got to now question? Maybe introduce yourselves and kind of tell us what leads you to be here. And let me get you some more microphones. I'll grab those.
I don't think so.
Lee, is this being live streamed as well?
Okay, so maybe we shouldn't be completely honest.
We got enough?
So I have been on the Court of Appeals for a little over 12 years now. Before my time at the court, I was a district court judge for 3 years. Before that, I worked for the Governor Huntsman. I worked at the U.S. Attorney's Office as a federal prosecutor. I worked at a private firm for many years. So I've done various different things that all led me to being appointed to the Court of Appeals. This is the job that I've had the longest, and it's the job that I like the best. I always knew I wanted to be a judge. I didn't necessarily know right at first that I wanted to be an appellate judge, but being on an appellate court speaks more to my skills. I love to read, I love to write, I love to take my time in making a decision, considering all the factors, considering all the law, and I enjoyed being a district court judge, but things happen so quickly in the district court. You have to rule on objections, you have to know the rules of evidence, and I feel that the Court of Appeals, and you saw what we do every day, it's better suited for my skills.
My name is Dave Mortensen. I've been with the Court of Appeals for 6 years. Before that, I was a district court judge for 10 years, so I've been a judge for 16 years. Before that, I was a trial attorney specializing mainly in injury and insurance law and a little niche called bad faith insurance law. That's where you sue your own insurance company and say that they were mean to you. And
Sounds exciting.
it actually was way more interesting than it sounded. The other thing that I did was I was what's called an insurance defense lawyer, and that means when you get sued and you have insurance, then you go to your insurance company and you say, oh my gosh, I've been sued, and they say, hey, relax, we'll hire a lawyer for you. Then they would call me, and I would be your lawyer at the insurance company's expense. And that included anything that can be insured, which is basically everything in the world. And so it's true. I have extensive experience in litigating livestock cases, like cows getting hit on roads or trains or other stuff. That sounds crazy. In fact, when I talked to the governor to get appointed, he asked, what do you have that everybody else doesn't have? I said, well, I bet nobody has as much experience in livestock cases as I have. And he laughed. He thought that was funny. And he's just like, as if you guys ever have livestock cases. Well, sure enough, my first year on the bench, we had a cow case. The computer, it's random assignment, but, the stars aligned. And I was the author of the case and wrote this very fine opinion about cows. And so, but I found out all sorts of interesting stuff. With these bad accidents. One of the things I tried to do, I didn't like math. That's why I became a lawyer. And as a litigator, all I did was math. If you do an injury law, you're just doing physics all day long. And I tried to. One guy, his car hit a horse, and the horse then slid down the road. And I tried to figure out from how far the horse slid, how fast the car was going, right? And so it turns out. That's why you have experts, but I was doing the math myself, and just to make sure my expert was getting it right. And we could account for everything. I know the coefficient of friction of the road, I can take the temperature and how much it's going to skid. And I actually know the coefficient of friction for a horsehide generally, but I had two problems.
What is it?
Well, I don't know what the number is now, but my two factors I could not account for is, number one, I didn't know exactly, although I had the time of year so I could guess at how long the hair was on the horse. That was a little bit iffy. But the real question that messed up the whole equation was whether the horse was sweating or not. So if the horse had been just hanging out on the road and wasn't sweaty, then it would have had a lot more friction, whereas if the horse had been running around and sweaty, then he was slid a lot longer with less force, which would have been a lower speed. So finally we had to give up, and we just decided we couldn't tell. See, but already I can tell by your faces, the case is way more interesting than you ever thought, right? So anyway.
The lessons we learned.
The lessons we learned. So before that, I got a degree in English as my undergrad, which means you do one of, well, I was going to say you have two options. You have three options. One, you can be unemployed. Two, you can go get a advanced degree and teach English. Or three, you can go do something else like get an MBA or go to law school, and I picked the law school route. These folks are very academic, and they're very, very smart. I just wanted to let you know that some of us are more normal. I picked my undergrad by its central location to rock climbing venues. This is no joke. I looked on a map and said, okay, here's where I want to climb in the winter, here's where I want to climb in the summer. Where is the middle? And that's how I chose where to get my undergraduate degree. I hope that you made a much more academic and wise choice about why you're here at SUU, although I would like being here because I can be in Kolob Canyon in minutes. Who else can say that except people who are going to SUU? So I hope you guys take advantage of the outdoor stuff around here. That was more that I should have said.
That was a lot. I have no idea how to top that. I did not come prepared with jokes, and I have no horse stories in my professional background. I'm a little bit at a loss for words. I am Judge Ryan Tenney. I am, as of 2 weeks ago, until 2 weeks ago, I was the newest member of the Utah Court of Appeals. I was appointed to the court last June and confirmed last August. We just very recently had a new judge who was confirmed by the Senate who's not joined us. So I guess I'm still the newest judge for a few weeks. Appellate law is very familiar to me. This is the world that I spent my career in. I was an attorney for about 20 years, about 17 of which were in appeals. I spent about a decade with the Criminal Appeals Division of the Utah Attorney General's Office, which is the division that represents the state in front of the Utah Court of Appeals and the Utah Supreme Court in all felony cases. So I spent a lot of time, I was about to say in this court, not in this room, but in the Utah Court of Appeals. I argued in front of Judge Christensen Forster. At some point we should figure out how many times, probably 20 or 30 times. Sometimes she got it right, and sometimes she did not. You usually got it right, usually. And then after spending about a decade doing appeals with the state, I spent about 5.5 years or 6 years the same job with the federal prosecutor's office in Salt Lake. So I represented the United States in criminal cases that went up on appeal to the 10th Circuit. And so appellate law has been what I've done for my whole career. We don't have a lot of horse cases, so the stars really did align for you. But I've been on the court now for about a year and 3 months.
Whoa, geez, I'm so sorry. I would like to, let's turn it over for questions for here before I ask the many that I have. So does anybody have a question?
So you've all three of you, thanks so much for being here. This has been a real treat to have your first live session in a long time hosted on this campus. Talk a little bit about why appellate courts are so important. What's your workload like? Are citizens being served in the way they should by that in our system right now? And what's something about it that's wrong? Because in humanity, there's always something wrong. What would you fix if you could, based on your experience? So that's three things. Thank you.
I'll take the first one or two, if that's okay, because they're the easier ones. Not a lot of people really understand the differences between the trial and the appellate process. It's something I think when I went to law school, I had no idea that there was this sort of different system out there. And when you understand the sort of basic way that we work, it's really a different world. Whenever you see a law show on TV, what you're seeing is the work of the trial courts, juries and witnesses and so forth. And once that process has concluded and it's done, whether it's a civil case or a criminal case, it comes up on appeal. And the work of the appellate courts is very different. We don't take evidence, we don't retry the case. What happens is the party that lost has the opportunity to write what's essentially an argumentative research paper, trying to point to the legal errors that the party thinks happened below. The court let in some evidence that it shouldn't have, or this statute was violated, or the Constitution was violated. And so the bulk of appellate work is done in long-form writing. The parties will write 50 and 60 and 70 pages. And then on occasion they'll come and do this, which is sort of a glorified debate process. But this is just a small part of our job. The real bulk of appellate work is just reviewing really, really long argumentative research papers. And one of the things that I really hope that the public has some sense of, to the extent that the public sort of observes the appellate process, is that you have this group of people, judges, law clerks, attorneys, and so forth, who really do read hundreds and hundreds and thousands of pages trying to sort through what the law says about the issues that happened, the issues that arose at the trial process, and trying to make sure that the law is applied correctly and fairly. And so our job, sort of at the global level, is to make sure that the rules were followed, to make sure we're not here to retry the case, we're not here to decide who we think we would believe or not believe. Our job, the thing that makes us different than the courts at the trial level, our job is to make sure that the rules were followed, and if they weren't followed, to decide what should happen. I'm biased because I spent my career in the system, and now I'm one of the judges, but I think the system works admirably well. Given the volume of briefing that comes before us, each of us on our court, we sit on somewhere between 9 and 11 cases, 9 and 12 merits briefed cases a month. Each of those cases has roughly 120 to 150 pages of legal briefing attached to it. And in the year and 4 months or so that I've been on the court, I've yet to go into a meeting with my colleagues after argument and find out that somebody had not read something. It's always the opposite. It's always somebody saying, oh, when I was reading those briefs the second time or the third time. And so there's just an extraordinary amount of work that goes into it. And obviously parties that lose at our court are probably not going to be happy. But one thing that I can just say, again, I'm biased, but nobody comes to our court or the state Supreme Court and doesn't get a fair shake from a group of people who tried really hard to grapple with everything that was in front of them and understand the hundreds of pages of reading that is in front of them. It just happens time and time again. And I think that the people of Utah should know, or it's important for them to know, that the system really is working the way that it's supposed to on this level.
I was just going to add, you asked what the problem is. What's the problem? There's a tension. When a case comes on appeal, the rules and the procedures are designed to affirm, in the sense of, we want stability, a decision has been made. Our perspective in looking at that case is, if we want stability, we want that decision to stand as long as it was legal, as long as it was correct. So when we review something, the hard thing comes when we have to look at it from that perspective. Can we affirm? Is this, is there a way to keep this decision in place? Personally, I may have not made that decision. I may have gone the completely other way. But the inquiry for us is it enough correct? Was it enough, did the court give it enough consideration that we can affirm? And so there's a tension there, right? My personal views don't matter. But when you get that case where personally you would not have done what the trial court did, we still have to affirm if it was enough right.
I would just add one more thing that people sometimes don't understand. When people always talk about what the law is, there's a couple of different ways we have law in the United States. One is there's a code, and the legislature creates laws, and they are the law. So, if the legislature declares that Snickers are better than Mars bars, that is the answer. And if they come to court and they're like, we like this other bar better, they're like, nope, the legislature told us Snickers is the best thing, so the end. And obviously they have to comply with the Constitution and all of that. That's one way the law is made. The second way the law is made is what's called common law. And we actually got this from England, and we're still doing it. And that happens a lot in the civil arena, that somebody decided that the law should be X, for example. I'll pull something out of thin air. You have a contract. Somebody says, I want to buy your car for $1,000, and you say, that's a deal, and they take your car and they don't pay you the $1,000. I'm sure it's no surprise to you that the common law says you can sue them for the $1,000. On the other hand, here in the state of Utah, if you contract with somebody to buy $1,000 of marijuana, and they pay you the $1,000 and don't deliver the marijuana, you can't sue them for that, because that's an illegal contract. You probably are going to have to resort to self-help, which is a terrible thing. But the courts aren't going to enforce illegal contracts, right? Or if you make a contract, somebody says, I want you to be my slave, I'm willing to pay you this much money, you're like, I'm kind of generally against slavery, but in this case, I'll do it. Yeah, you can't go to court and enforce that contract. That's just not a thing, to be an indentured servant. There's some remedies. You can get, your money back and back out of the deal. We'll let you have rescission or whatever. But here's the key. When the case comes to the district court and you read in the newspaper that a court made such and such a decision, it may have been a good one, it may have been a bad one, but it only matters for that case. Now it comes to us. And you heard 2 cases today. Sometime in the next few weeks, we're going to get together. One of us is going to write an opinion. The other 2 are going to have input into that opinion, and then we're going to publish it. It's not only going to decide this case, but it becomes the law. So whatever we say in writing with a majority vote is the law until either the Utah Supreme Court or the Utah legislature changes it. So that's a way that judges make the law. Now, usually what we're doing is just interpreting what the legislature said. And if they like what we did, then they'll just leave it alone. But occasionally they're like, you guys are crazy, you Court of Appeals judges. And then they're free. The next session is in January. If they don't like what we do, they can change it. And we've got no problem with that because that's their main job. So we're all good with that. But it's important to recognize that the appellate courts, what we publish becomes the law of the land until changed by somebody.
Can you do that with tenure applications?
So where do we find Judge Martin?
So our cases are all published. You could go to a site. It's utahcourts.gov, utahcourts.gov. And if you clicked on About and went to the Court of Appeals, they will list every decision we've ever decided by year. You can go read them all.
Back to 2007.
It doesn't go before that? Oh. Well.
No, 1999. Sorry, 1999.
There you go. So you can go back quite a bit and see what we've done. And, you can go back to the Utah Supreme Court cases back to 1897. Good luck understanding some of that stuff back then, but it's there to be read.
So talk about your workload just a little bit.
Our workload is robust. This year, 1,000 cases have been filed with our courts, so the 7 of us will have to wade through those 1,000 cases. But that's just 1,000 is a lot, and especially when you have to write it up. And so that it's a lot of cases. But just to put it in perspective, the justice courts, so where you see traffic tickets, I think they decide about 38,000 cases a year. So that doesn't make our 1,000 cases seem that big of a deal, although some of those are resolved in 3 minutes. You go in, you say, yeah, I'm guilty. The judge says, okay, you paid $200. That's the end of the case. And so there's not much to that, but the volume can be quite big in the lower courts. But yeah, we have plenty to do.
Jason, do you want to?
I just was going to say quickly, one distinction, there's many distinctions between the Utah Court of Appeals and the Utah Supreme Court. We have to hear every case that is filed with us and that comes to us. The Utah Supreme Court, on the other hand, gets to pick and choose the cases that it wants to hear. So that is one distinction that affects the workload a little bit.
They won't hear a case that you maybe have. Does that mean that they supported your decision then?
Not necessarily. It just means that,
They just don't want it to go further
yeah.
necessarily.
Jason.
So this is in a little bit of a different direction, but as someone who law school is on the table for the future, what is something about your careers, either as an attorney or now as a judge, that you did not know when you were in law school and you either wish somebody told you or just has surprised you since you've become lawyers and become judges?
Good or bad, or both, I guess. I think I, sort of like Judge Mortensen, I was a history major in college, which I loved, but it didn't leave me all that many options. And so I went to law school sort of as, not purposefully, but sort of as a default. And what I discovered when I got to law school was how much I loved it. I loved all of the topics. I loved all the interaction. I loved the debate. I loved the learning everything that I was learning. Unfortunately, private practice or practice is not exactly the same as law school, so I was surprised, very happily surprised on the one hand, and then when I went to go actually have a job and work, it wasn't as fun as law school. But I do really, really enjoy my job. And I was frankly surprised at how much I loved law school.
Am I on? There we go. One of the things that I've been struck by, I don't come from a family of lawyers, although after I went to law school, siblings and so forth have gone. I didn't fully understand how much variety there is in the practice of law until I got out of law school and really kind of had been a few years out. I think so many of us think of Law and Order or whatever legal TV show that we've seen, and we think, well, that's what lawyers do. But there are all kinds of lawyers doing all kinds of things that have nothing to do with going into court and arguing. I have a sibling who is an in-house lawyer for a company, and our jobs are not the same job. We don't do the same thing day to day, and it's a little bit weird that we share a common degree. And so if you think about those of us that have been to law school and have law jobs, there are lawyers who do nothing but write wills. There are lawyers who do nothing but litigate divorce actions. There are lawyers who do nothing but do complex litigation, which is just own world. There are criminal prosecutors and so forth and so forth. There are lawyers who represent universities. And my friend Meb is here and works here for SUU. And his job and my job are very, very different jobs. And so I had this idea going into law school that, oh, this is the thing that lawyers do, you know, and that the only people who should go to law school are the people who want to be on TV sort of cross-examining somebody. And there is a place in the law for those people, but there are people who have never set foot in a courtroom who are lawyers. There are people who, you know, they're very into business, and they went and got a law degree so that they could do the law parts of business. And that's something I don't think that I understood until I'd been out of law school for a few years, is that there's an awful lot of variety in our profession, and there are people who do a lot of very, very, very different things with our degree.
Question?
Yes, first of all, welcome back. It's good to see you again here at Southern Utah University, and we always appreciate you taking the time to speak to us. The most persistent question that I get from my students when we're discussing the judiciary, both state and federal, is how do judges keep their personal prejudice or preference from influencing their decision in the case? And I respectfully argue that they do their best, but they can't. And as proof, I use the example of two cases that have recently been the subject of public interest, Roe versus Wade and Dobbs versus Mississippi. And what changed? Members of the court changed. And on the right, a deliberate effort over many years to install judges who were somewhat known to favor overturning Roe paid off when Amy Coney Barrett was confirmed. But prior to that, Roe, Casey, one could argue the court made real attempts to keep the abortion right as defined by Roe and Casey pretty much intact. Alito, as you know, just threw it all out, overruled. The law hadn't changed. The justices had changed. How do you go about trying to be, and you're appellate judges, so in my opinion, I may be wrong, it's a little easier at the appellate level than at the trial level, but how do you keep your own policy preferences out of the rulings that you make as appellate judges?
Well, the real answer is we try real hard. But we're human beings. But there are some checks in that, and one of the checks in that is having colleagues. If I write something up and it seems to be influenced by a personal preference rather than fidelity to the law, hopefully one of these two will say, you know what, you're kind of stretching there. either in the result or in the logic used to justify the result. And so there's one check there. The other is I can tell you that I know that I'm doing okay with that, in that there are decisions that we issue that I disagree with. I disagree with what is happening, but I acknowledge that it's what the law is. So if I were God, this is not how this case would go. But that's not the job I've signed up for. Lucky for all of you. And so that's not the way it's going to roll. And in fact, we just, one got issued. If you wanted to go look at the latest case issued by our court this last week, I don't think I'm saying anything out of turn because it's right in the opinion. It was written by Judge Christensen Forster here, and I was on the panel. And we write right in the opinion that we recognize that this doesn't make any sense, and it's the legislature's fault, and so hopefully they'll fix it. But the result is kind of a goofy result, but that's the way it rolls. And so when I find that I'm doing that I'm issuing opinions that I fundamentally, on kind of the world is seen by Dave view, I don't agree with, but I'm doing it anyway, then that feels like I'm still doing the right thing because I'm having fidelity to the law and not to the results that I want.
And one thing you also have to know about Utah has we are not elected judges, right? Our politics, in fact, constitutionally, our politics are not to enter the selection process, the equation about who's going to get picked. We take an oath to obey and defend the Constitution, and I know federal judges do as well, but in being selected for this position, first we have to go through a nominating commission who looks at all of our resumes, our writing samples, our professional experiences, talks to people that we have worked with, people who have appeared in front of us if we were prior judges, talk to all of our colleagues, opposing counsel. That nominating commission knows a lot about us. Once that nominating commission makes its decision about whose names they're going to send up to the governor also goes through that process, looks at everything in our application, talks to people to know if we are result-oriented people or if we have some fidelity to the law. And then we have to go through the Senate confirmation as well. It is an extensive process, and I think that process itself has a tendency to weed out people who would maybe want to have this position for their own means, or because they are politically motivated, or because they are result-oriented. I think that helps. I think, at least in the state of Utah, that helps a lot.
I'm going to jump in with one piece. I've got a voice in my head saying, don't wade into the question that started with Roe and Dobbs. But I'm not going to talk about Roe or Dobbs. One of the things, though, when I hear that kind of question or it comes up at tables or whatever, we have to be careful when we talk about courts, how specific we're talking, sort of what level of granularity we're talking about. Without getting super nerdy about it, certain kinds of cases go to certain courts. And it's certainly true that these sort of big questions of what the Liberty Clause of the 15th or the 14th Amendment or the 5th Amendment mean, those get funneled through the federal court system and they make their way to the U.S. Supreme Court and so forth. But the vast bulk of litigation that happens in the United States is not of that kind of structural question. Does the United States Constitution protect the right to an abortion? The vast majority of litigation is about the stuff that you and I would go into court about. Getting divorced from my wife, who gets the kids, how do we adjust alimony? My neighbor got convicted of this crime. It's a felony. It's obviously a huge deal to him and his family. But these are not the stuff that gets onto the front page of the New York Times or the Wall Street Journal, right? And so the question gets asked, or sort of pejorative labels get thrown out about, will judges bring in their biases? And I know that wasn't quite your question, but I've been on our court for a year and 3 months, a year and 4 months. I have no idea what the political leanings are of my colleagues in the court. And one of the reasons is that I've never asked. But one of the, I think the real reasons is that the kinds of cases that would sort of trigger some sort of discussion of something that would seem like politics just don't come up in the Utah Court of Appeals. We are deciding lawsuits. If you sat through today's cases, a defamation case, which matters a lot to the two parties involved, or the civil stalking case, which matters a lot to the parties involved, but those are not the kinds of things that would trigger some sort of, what's your partisan leaning about defamation law? What's your partisan leaning about civil stalking statute and how to interpret it? And so, there's certainly room, I think, for healthy discussion of judges at a certain level and the degree to which their own personal political opinions factor in. I think that some of them would tell you that what they're really examining is the structure of the Constitution and so forth, and that discussion could be had. But one of the things that I always instinctively want to push back on when I hear sort of the broad brush argument that the judges are sort of partisan actors in robes is, well, at the district court level, at the state level, they don't really have the opportunity to do that. That if you were a partisan warrior, you wouldn't really want a state trial judgeship. You really wouldn't want a state court of appeals judgeship. For the most part, you really wouldn't want a state Supreme Court justiceship. Those cases are really few and far between. And so the vast, and the word vast is doing a lot of work in that sentence, the vast bulk of cases that work their way through the trial levels and the appellate levels are really about stuff that would not trigger any sort of partisan impulse. I mean, it's true that there are those exceptions, and they kind of swallow all the oxygen in the room. But it worries me a little bit that we have this sort of popular narrative that judges are these sort of partisan actors when the vast majority of what we do really does not touch that kind of stuff at all.
Can I have one question to this? If you were selected to be on a panel and you had some level of association with somebody in the parties in this case, what
We recuse immediately.
What level, how, where does that level go? I mean, immediate family, obviously, but what makes you decide, okay, I'm going to recuse? Where does the rubber meet the road on that?
The question is, when do we recuse? The standard is when our impartiality could reasonably be questioned. So that's actually a lower standard. So there could be a circumstance where I can say to myself, I can look in the mirror and say, I am not biased in this case, but I recognize that my impartiality could reasonably question, and so I'm going to get off this case. And it's relatively easier on our court because we sit in panels of 3, but there are 7 members of the court. So if I jettison off a case, not the end of the world, one of the others is going to step right in. We're not going to miss a beat. Now, there is a rule that if all 7 of us are conflicted out, then none of us are.
Oh. Is that a real rule?
That's a real rule. Because otherwise, the end result would be nobody could hear your case, right? So, it's, are we generally against murder as a group of judges? Well, yeah. He's against it. He just told me. He's just against it. So can we hear murder cases? Well, yeah. We're not biased.
What's your opinion on horses?
On what? Horses. I like horses.
Maybe this guy wasn't the person who tried it. I mean, he may have committed it, but his rights may have not been.
Sure, sure.
So that's what you're looking at. Not so much was he guilty, but did the court treat this person fairly? And
Right.
What he deserved by the code were those standards met?
And to piggyback off of your response to that point, I mean, let's just use the criminal case as an example. When an appellate court reverses a criminal conviction, the vast majority of those instances, the court is not even weighing in on the question of whether the court thinks the person did it or not. What the court is weighing in on is, was this statute violated? Was this rule violated? And a court can write an opinion saying this rule was violated, this constitutional provision was violated, without even touching the question of did the person do it or not? And that gets into this sort of big picture question of, should courts be doing that? And the answer under our constitutional system is yes, because people have entitlement to have their constitutional rights protected. And conversely, if a court is affirming a conviction, you can have a lot of scenarios, without getting too deep into the weeds of criminal appellate law, but you can have a lot of scenarios in which an appellate court might affirm a conviction, and in the judge's minds, they might be thinking, if I was on that jury, I might not have convicted that guy. but a jury of his or her peers heard the evidence, convicted him, and in my view, the rules were followed. And when you understand that that's the role that we're playing, and then when, going back to something that Judge Mortensen was talking about a minute ago, we sit in groups for a reason. You know, we all have different backgrounds, but when we go in, what happens after argument is we go into a conference room and we talk about the case and we take a preliminary vote. We'll be in that room for an hour or two, and sometimes longer, and sometimes we'll then table the discussion and come back and redo it again in a week or two or a month or two. And if somebody is coming at it with a particular bent, well, they're going to get outvoted. But that discussion is designed to weed that out. That's why the system is set up the way that it is set up.
All right, let's take us home. One last question.
Hi, my name is Cade. To kind of play off the first question that was asked, hopefully this question isn't redundant or anything. I'm a freshman here at SUU. It's my first semester. I feel like I can speak for probably many, but I feel a lot of pressure to kind of pick a major and stick with it. My problem is I kind of just am interested in a little bit of everything. So my question for you guys is, where does someone who is interested in law start, and what does it take to be in that field that you're in? And maybe include where you guys started, besides rock climbing, but what affected your decision to become, to be in the field that you're in?
First off, I think you should remain open to things. Now, obviously, at some point, you're going to have to decide what your degree is going to be, but on the other hand, if all of a sudden you're sitting in the same old classes and you're like, I think I might hate my major, then you probably should change it. But you should also be open. Judge Tenney talked a little bit about it. There's a lot of things in the law that he didn't know existed when he went into law school, and he's probably even now, 25 years later, still bumping into people saying, this is what I'm doing in the law, and you're like, I didn't even know that existed. That's what's happening to me. And so that was kind of my experience. I went into law school, and the way I narrowed it down to law school is I had this English degree. I like to write, and I like to read, and I thought, you know, those MBAs, they don't seem to be reading and writing. And I wasn't going to go to med school because there was the whole math thing to begin with, but there was also the fact that I used to write personal statements for money. People were applying to med school, and I'd help them write their personal statements. Because they can't write. Doctors, they're terrible. And it's not just their handwriting, their actual logic and everything they put in those personal statements. I'd be like, why are you telling those people those things? It was just crazy. But you learn what you're kind of good at, and then you decide. I went with a firm that put me in courtrooms a lot, and along the way I decided, I wasn't one of these people who in 8th grade decided to be a judge. I was in a courtroom, and after a while I looked at the person in the robe and thought, I could do that, and decided to become a trial judge. And then along the way I had some experience with appellate law. I had practiced in front of the appellate courts. But more and more I thought, I think I would like that job, because what I liked most about being a district judge was reading and writing. And so this job has that. So just keep your mind open, and if you find things that you find are interesting and you like, then definitely go in that direction.
What? Oh, sorry.
I was just going to say, and it does take a little self-awareness, right? Like, you do have to, at some point, have some thought about what you are good at, where you have found success in your college career. I started out as an engineering major.
Really?
Yes, only to please my father, but that's another story. But I did not end as an engineering major in any respect. So you have to at least be aware of what your skill set is and what you enjoy.
The other thing that I would throw on about law school in particular that I did not know until I got to law school is that law school as an institution does not presuppose that you know anything in particular when you show up. There are certain grad programs that do. My understanding is you can't go to med school unless you are one of like 3 or 4 different majors. med school requires that you have a particular background or sort of a range of background. You can't just show up. You can't go from being an English major to be to go to med school. That's my understanding. You can't go get a PhD in chemistry unless you have a chemistry background. But law school does not carry that assumption. One of my close friends in law school was a piano performance major. One of my other close friends in law school was a zoology major. You have a lot of science background people who then go to law school so that they can become intellectual property lawyers. You have a lot of people with business backgrounds who go so that they can be business lawyers and so forth. I mean, you find a lot of English majors and history majors and a lot of poli-sci majors just because there's nothing else to do with those degrees. And they sort of funnel, the kinds of people who would be thinking, I want to be a lawyer, would sort of choose poli-sci or history or so forth. And so those sort of take up the bulk of them. But you can have virtually any degree and get into law school, which is its own animal, but get into law school and you're fine, because law school assumes that it is going to teach you the law. It doesn't assume that you come with something particular. So if you're enjoying your undergrad program and you're thinking, well, I'd like to go to law school, just do your undergrad program and then apply for law school and you'll be fine.
Thank you very much.
Thank you so much for having us.